welcome everyone. This is a ACEDS event brought to you by the Ohio chapter. We're hoping this will be an interactive event. We're also hoping that many of you have had an opportunity to review the proportionality framework that we circulated or sent a link to. If you haven't, don't sweat it. Because we have experts here today that are going to talk to you about the framework. We have people who were involved in the project itself and can talk and give some background on it, as well as describe what it's all about. So with that said, I'm going to turn it over to, we're going to do kind of a fireside chat, and I'm going to be asking questions, and we have Sonia Judkins and Tim Opsitnik to answer some questions. We're also going to have John, and I'm going to say this probably wrong, Rabio?
It's Rabier.
Rabier. John Rabier join us, who is also was also involved in developing the framework. So with that said, I'm going to first ask Sonia, do you want us to, oh yes, and as Pam just put in the chat, please feel free to put questions in the chat. We do encourage questions throughout the discussion. So if you do have one, put it in the chat. Pam's going to keep an eye on it and break in with questions that she thinks we need to answer at that point in time. Also, just a reminder on the agenda, we're going to do probably about an hour for this panel discussion or this fireside chat talking about it. Then we're going to go into breakout rooms. We really think it's important for you to be able to talk about your thoughts about the framework and how it might impact the industry and whether you agree with it or don't agree with it or changes you'd like to see in it. And then we want each group to report back, because it's really important to Tim and Sonia and the rest of the team that put together this framework to gather feedback and see if they need to make changes. So really looking forward to getting your input on that, and hopefully that's of great value to all of you. So I think that's my last housekeeping thing. So with that, I'm going to ask Sonia to go ahead and tell us a little bit about yourself and kind of your background.
Okay, well, happy afternoon to everyone. My name is Sonia Judkins, and I am the Senior Manager of Discovery and Information Governance at T-Mobile. I'm located in Reston, Virginia, so close to DC. And prior to joining T-Mobile, which was as a result of our merger last year, I was also the Manager of Discovery and Information Governance and Compliance at Sprint for about 12, 15 years. Part of my function and responsibility includes everything used to be at Sprint, from handling the records retention, the policies, the training, the guidelines, the legal holds and preservations, collections, and then obviously purging of data and decommissioning of systems, working with various groups across the company, obviously in response to litigation and regulatory matters. One of my core focuses is really compliance driven, figuring out how can we do it better, faster than the next person, but still follow the guidelines and making sure that we are following all the requirements. So I am excited to be part of this call, and I'll pass it off to Tim.
Thank you. Thank you, Sonia and Julian, and thank you for having me today. This is great. Always excited to talk about things that you've been working on for a while, and we hope that we will get some great feedback from all of you when we take the time to go through the breakout sessions. But in terms of my background, I started my career working for Jones Day as a lawyer. I worked there about, I'm going to probably give up my age doing this, but I was there for about 15 years, and then a little over 20 years ago started my own technology company called Jurinov, and then about 5 years ago merged it up and into a larger technology company, e-discovery company, TCDI, Technology Concepts and Design, where I currently am the executive vice president and general counsel. And so I've been involved in e-discovery issues since early in my legal career, back in the early mid 80s. And I've also served as a special master and an expert witness, and so I've done a lot of things. Participated on the steering committee for Sedona Working Group 1, dealing with e-discovery, as well as the steering committee for this project. So been very involved in these things, and look forward to continue my participation in bringing this project to fruition.
Well, thank you both. Can you tell us, like, how did you get involved in this project? Did somebody call you, knock on your door? Probably not because of COVID, they didn't knock on your door, but how did you hear about it? How did you get involved? Did you volunteer? Were you recruited?
So I'll start. I was recruited. I was minding my own business, as I like to say. And then somebody's like, I think you should help. I'm like, I think that's like for somebody else. And part of that was really a hesitance because I'm not an attorney. So that made it even more scary a little bit. It was a little bit out of my comfort zone. I'm like, nobody has to care what I have to say. And actually, I got the comfort of they actually do want to hear what you have to say because I'm on the ground actually doing the work. So that part was very refreshing. So a friend of mine at a law firm said, hey, and why don't you join? And I'm like, okay, I'll do it. So, and I'm glad that I did. I learned a lot. I learned, clearly just not even just understanding the rules, but like, why is it important? So definitely recruitment. I'm a person of, I loan my own spot, but to step out was challenging. But at the end of the day, I'm glad I did it. I learned a lot of different things, and just from a different perspective, because I have the corporate view. So it was helpful to look at other avenues.
Excellent.
Tim?
Tim?
Yeah, I would have to say that my involvement came along because of the relationship that I had with John Rabier all these years. I first met John when his involvement with the Civil Rules Committee, and later Sedona, and on to Duke, and now at George Washington University. And when John moved from George Washington or from Duke to George Washington University, we became a center sponsor at George Washington University, and proportionality was something that I knew that John had great interest in, and he's been working on for a very long time. As I said, first as part of the Rules Committee in Sedona, and then even that he had a conference in San Francisco, and I want to say it was 2016. I say that because I remember, I think it was 1 year after the federal rule amendments, which 2015 was the proportionality changes, where they were brought more to the front of the rules. And John had this conference in San Francisco and also Washington, D.C., and he asked judges and lawyers and others, hey, what do you think the rules have done? Have they had an impact over the last year? And so we went through that whole process, and lots of people had lots of opinions. And I think the one opinion that I took away from it was that we talked about it a lot more. It became more towards the forefront, but we still were having a really hard time quantifying it. And John has now joined. And John, I'm going back to San Francisco when I think I really, these topics sort of started percolating in my mind. And so we were going through and we were saying, they haven't really had other than bringing attention to it, we haven't seen a lot of changes. And so how do we measure these changes? How do we move this along? And then sort of along the way, proportionality, and John continued on this path. And I was, I'd seen different projects we were working on at Duke and elsewhere. And when we got to, I met Mandy Ross at Optics, and she said they had the software program, and they were looking at how to approach arguments and set processes and procedures for who to collect from and how much. And I said, well, this whole proportionality concept, this is squarely before John. This is something that John Robbie has been working on forever. You've got to meet John, and so we started talking about this, and John has been talking about trying to develop a way to call balls and strikes on proportionality for a long time, and so it was great, and I think we all then just sort of envisioned, hey, wouldn't it be great if we could put together a little bit more of what I refer to as a social scientist approach to these things, rather than the seat of the pants way that we lawyers do it now. If there's anybody out there, we certainly put more thought into this than the seat of the pants, but that's a long way of saying that how I got involved. And so I credit John, and as I said, TCDI is a sponsor, and it's something that we feel very strongly about it. John's joined us, so John,
well, Tim, I love the analogy you put forth of calling balls and strikes on proportionality. I think that's great. And John, welcome, and thank you so much for joining us. We're going to circle back around to the very first question, which I asked Sonia and Tim, which is, tell us a little bit about your background and who you are.
Good. Thank you very much for inviting me. I've been looking forward to this opportunity. I do want to thank Tim. I do want to thank TCDI, one of our main sponsors, and has been a steadfast sponsor, particularly when we're starting up this program here at GW. So I really do appreciate and thank you, Tim. Real quick background, because I think it is relevant. I spent 30 years in the federal government, 20 years 30 is with the Administrative Office of the United States Courts. That's the single agency that provides service to the federal judiciary. For 20 of those years, I headed the office that staffed the Judicial Conference Rules committees on appellate, bankruptcy, civil, criminal, and evidence rules. I worked with committees that were consisting of about 6 federal judges, the top officials from the DOJ, Assistant Attorney Generals and Deputy Attorney Generals, Supreme Court, state Supreme Court justices, and 3 attorneys, all appointed by the Chief Justice. I had the honor to work with 3 judges as chairs who eventually got elevated to the Supreme Court. And so and I worked closely with them for 3 to 6 years. So that was quite a privilege and an honor. After I left the AO, and incidentally, just when I was leaving the AO, we were still working on discovery. We had been working on discovery since 2000 in serious, where we first came on the advent of electronically stored information. So we worked on those amendments for all those years. And then as I was leaving the AO and the rules committees, we had already started thinking about proportionality and a way to somehow put a break on discovery. The committee had been working, if you look through it historically, since about 1980, on breaking the discovery as a result of the 1960 amendments, which basically changed all the discovery rules and opened it up to everybody and made it very, very liberal. And ever since then, the committee has been trying to put reasonable limitations on it. So we were deep into proportionality. I left the AO, was the executive director for Sedona Conference for a year, went over to Duke for 7 or 8 years. I was the director of the Center for Judicial Studies. I developed a program of conferences in 3 main areas: MDLs, mass tort MDLs, class actions, and e-discovery. And now I've brought those programs over to GW for the last 2 years. We're going to hold our first in-person conference coming up next week. I hope to have this e-discovery and a review of this proportionality next spring, probably in April. So that's
Excellent.
my background real quick.
Well, thank you, John. That kind of answered, I think, number 2, which is how you got involved in the project, because it sounds like you're passionate about it. And number 3, why it was needed. Sonia, I think we heard from Tim why he thinks the project was needed, but do you have a thought on why you felt compelled to join the project team?
Yeah, I would say that as I stated earlier, just kind of having a seat, not being a lawyer, was really important to me, because I'm one of the people that, you know, I'm usually the one getting the information and just digesting it and complaining about it. So now I had a voice to speak about it, you know, and have an impact, which you don't always get. So I'm very honored to have been able to be just a small, you know, spoke in the wheel of just saying, hey, you know, it's uncommon. We often get, you know, requests from the government or opposing counsel, and just the, you know, the idea of proportionality is, to me, in my mindset, something very common and should be obvious, but it is not obvious when you get those subpoena requests. So if there's any way to kind of put some framework around it and give it some baseline, then I'm all in. So definitely.
Excellent.
Just to follow up what I said earlier, I mean, why I think it's so important is I can't tell you the number of times I've been working as an expert witness and our clients say, we've got to frame our burden arguments, our proportionality arguments, and it's just so hard. Everybody's always so focused on dollars and cents, and you know, they don't necessarily pull out and tease out all the things that that we as practitioners need to make those decisions, let alone what the judiciary needs to look at when they need to you know, make decisions about whether or not, when enough is enough. And so that's, you know, finding a method or way of doing that is the real value that I saw to this.
Excellent. So in reviewing the final document or the current state of the document, I noticed on the page all the authors and all the people involved in it. And it looked like, I don't know, 20, maybe 30 people were involved in this project. How did y'all interact? How did it work? Because you have an awful lot of people from different backgrounds coming together to try to figure this out. Was it consensus? Was there debate?
No, so John did a great job of initially setting things up into different sections. So I think there were 4 main sections and we kind of had different groups. There are a couple people on this call like Mandy Ross who we would not have been able to do what we did without without her. So there's other people
Thumbs up
that
for Mandy.
Yeah, hands up for Mandy. Thanks to Mandy. So I think breaking it out in teams and kind of digesting it, much like you do a case, you know, you have core teams that are working on different things and focus on that. I think there was definitely discussions, and they weren't always just everybody listened to one person. Everyone got the opportunity to say what they thought and provide real content and numbers behind the facts. For example, I was on, you know, section 3, so we were talking about particular costs for different sources. Well, my cost as a corporation might be different than, you know, another cost of a corporation. So really getting into the meat of what we're talking about was really helpful to shape where we were.
Yeah, just a little more on the process. The final document has basically 4 sections. We divided the group into 4 teams. The teams, I think all of them, held bi-weekly 1-hour calls, meetings, status calls. And they did this for about a year and a half. So you're talking 18 months. Mandy attended a lot of them. Mandy also had minutes of a lot of these calls for people who missed the calls. She would circulate it to them so that they kind of had a heads up. So this was pretty intense. And the last section was on costs. They developed the Appendix F.
Yeah, the only thing I would add to it is we first started with a high-level outline, and then we broke it down, and that's how, you know, broke it down into 4 sections, and that's how that started. But you know, the one thing that I just need to make sure that we all recognize is, you know, the problems like this are solved by lots of smart people who don't care who gets the credit for solving a significant problem, and that we can't say that enough. A lot of people involved in this and trying to develop consensus and not caring about who gets the credit, and that's really how this was done.
Excellent. So it sounds like one challenge was it took a lot of time and a lot of people and energy. Were there other challenges just with the size of the group and collaborating, other challenges you faced during the project?
Yeah, I mean, the biggest one, it was a fascinating one because you're dealing with personalities and dynamics. The initial stage of the drafting, we were aiming to get a consensus, a general consensus document, recognizing that it was the producing party who really had all the information and who would be the one responsible for developing this new framework. But nonetheless, I wanted to get the plaintiffs, which typically are your requesting parties, involved, not so much as to getting their agreement, but to get their perspective. In other words, where the defense guys were saying, well, this is going to cost this much, I wanted to hear the plaintiff guys saying, no, that's way too much, and take that into consideration. Well, as the process went on for 3-4 months, they provided us, and we had 12 pretty good plaintiff lawyers, provided some really good insights. We made some changes to the document to address their concerns, which were very reasonable and made a lot of sense. But they wanted to go down a different track. They didn't want this to be a producing party's tool. They were seeing this from the perspective of, well, this is what's coming in front of a judge, and it seems to have the imprimatur of the plaintiffs and defense bar as to the merits of any of the assumptions or estimates. So they, of course, were getting very skittish, and they didn't want to put their fingers on any of this because you didn't want to go to the judge and basically saying, well, yeah, we're stuck with these results. So they wanted to go down a different approach. They would mandate agreement on all the cost assumptions, which would require the producing party to divulge confidential information. So you got that whole coordination issue. And so in the end, they decided to leave. And in the end, it made this process cleaner in that now it is not described as a plaintiff defense type of tool. This is a producing party's tool. Producing party has ownership. They can keep it confidential, or if it goes to the court, if they are, they could divulge as much information as they want. If they want to facilitate their negotiations with the other side, they could bring it up as well. But they own it.
Yeah, in developing consensus, the idea is to allow yourself to be influenced by others. And, there are some people who have agendas and personalities and other things where they simply don't allow themselves to be influenced by others, and they find it's a win-lose situation rather than a collective a collective attempt at finding a solution to a problem. And that's probably the number one issue that we had.
Okay. Not shocking.
Yeah.
Not shocking at all. So now we get to the meat of it, which I'm pretty excited about. And particularly for those who have not had a chance, I don't want to call people out and say, have you not had a chance to look at it? Maybe we'll say, who's read it cover to cover? Put your name in the chat. But in addition to that, I'd love for you all to provide an overview at this point of the framework and what it is and how it works. And then after we get an understanding of what it is, we're going to have John explain the expansion of the scope of the project, which was, I think, pretty recent. So we'll want to talk a little bit about that as well.
it may make more sense if I can go into the expansion right now, because I would explain the new framework and see how the expansion builds on what we've done.
Okay.
And let me have 5 or 7 minutes on that, because I think it will simplify it. And I'll talk about it at the 90,000 foot level.
Okay. Pam, can you share that graphic?
I sure can. Hold on 1 second here.
I spent a lot of time on this graphic, as you will see. This is a
it's
professional.
Color, it's the only one without color, John.
But for those who, while we're having Pam pull that up, for those who haven't seen it, I mean, this is to what I would call a mathematical computation of your proportionality, and you actually consider different factors and score them, and it kind of says, yeah, this is too much to do and this is not enough to do, and you'll see that in the chart that Pam's getting ready to share. So
yeah, good, thanks. Okay, so this will take about 5 minutes or maybe even less. So the new framework it's a modeling tool that provides an analytical framework to make proportionality decisions under Rule 26B1. Now, it breaks away, and this is the key, and the innovation that Mandy brought to the process. It breaks away from traditional practice by focusing on the discovery of individual custodians rather than aggregate discovery costs for all custodians. It has 2 main components. It's a modeling framework to assess proportionality, and it also has a sophisticated cost predictor Excel spreadsheet, which can be used independently to project discovery costs from 5 different data sources. Now, the development of the framework over the past 2 years has gone through a tortured journey. The July draft, and it's about like 20 pages without the appendices, was circulated to you, is being revised to expand its scope by taking into account all the pertinent Rule 26B1 factors. Now, a big challenge with this project is that it can easily overwhelm a lawyer or judge unfamiliar with discovery. We're still working on ways to simplify a description of the new framework. It's really intended to represent what experienced lawyers and e-discovery experts do today when they get a discovery issue, and how do they manage it. We're really just reflecting what good lawyers and good experts do. Now, before going into the details that I'm sure we'll be talking about, I thought it'd be better to go through the main steps using this chart of a hypothetical that's based on Microsoft's submission to the Rules Committee a few years back. They spent a long time coming up with data on their own litigation. They came up with averages of all their different types of cases that they've had. So the modeling starts and here, what we're doing again is reflecting what you guys do whenever you get these cases. And that is, number 1, you identify the scope of the discoverable matter. You figure out what the case is about. Number 2, you identify and then you rank the custodians by the importance of information resolving the issues of the case that they have in 5 common data sources: email, shared files, mobile devices, laptops, and another one. Number 3, you map custodians by their rankings and the degree of burden in accessing information from their data sources. So if you look on this chart, think of it as a graph. The y-axis, you have the importance of the information, basically what's relevant, what's not relevant. As you get higher on the y-axis, the information is more important. The lower ones, as you get lower, the importance of the information is not as significant. So you see in this situation, after talking with a lot of you and with looking at Microsoft, what seems typical is maybe 3 custodians who have very, very important information. So you see John, Joe, and Mary, they're ranked right up top. You got a couple who have important, Jack and Judy. So you're basically dealing, usually what I've heard from you people is 3 to 5 custodians. Then you've got to get people underneath that. So you've got a lower level, you've got Larry, Alan, Roger, Lou, Trevor, Gordy, and Sue. They have, their information is not as significant. And then you got 25 others. Now this, who are on the bottom end, this replicates Microsoft. They basically said they have 40 custodians in each case on the average. And this is how it works out. And you can see each individual custodian obviously has different data sources. So if you look to in the left-hand column, those are email sources, right? And that's why you have most of them on the email, because you usually get emails from your custodians. Then you get the file shares, then you got the social media, computer, laptop, and mobile devices. Now, the fourth step of a new framework is to project and calculate discovery costs for every mapped custodian using per gigabyte cost and typical volume. So if you look on that chart, on the x-axis, you've got the 5 data sources: email, file shares, social media, computer, laptop, mobile devices. What we did is come up with a per gigabyte cost, which took a long time, and obviously is based on layers and layers of assumptions. And you can say that, well, this is nothing but a house of cards. On the other hand, we are dealing with a huge aggregate amount of data. And that if you have that much data, you can come up with some kind of general ballpark figures, not to mention all the experience we have from the individuals working on this project. So the numbers that we came up with was that in a typical case, you get 5 gigabytes of email. Each gigabyte was, comes out to about like $6,000 per gigabyte. So that for each custodian, based on a typical volume, that's $33,000 for that individual. So if you look at the top, if we're going after John, Joe, and Mary, those are 3 custodians. We're going after their email. That's $99,000. Those are your top people that you're going to discover. You go to the right hand, you get the file shares. File shares, you see that the typical volume is 4.5 gigabytes, and that comes and the per gigabyte share is less, so that for 4.5 gigabytes, it costs you $10,000, 10.5. And you can see that John, Joe, and Mary have it, and the others. You go to social media, that's where it gets kind of sophisticated, and the numbers are really interesting. They're all in our appendix. They're all explained there. And all these numbers, all these assumptions that are in the appendix, they're in the Excel spreadsheet. It's a dynamic kind of a worksheet. You can change those numbers. You can adjust it. These numbers are based on our collective experience. So you can see it's $8,500 for social media. The gigabytes is only a quarter. Computer, laptop, you're dealing with a lot more gigabytes if you take it out of individuals, and that's why the cost is higher. So now you've got the cost, you've got the average cost. You can total up the entire. If you take all these costs, you just do the calculations, do the math, you come out with $2,622,610. If you include all of them, right? That's what it would cost for this entire universe of custodians and their databases using these averages. Of course, in the individual cases, then you've got to then take into account how much of that 2 million do you really want us to spend? That's where you got to go to the Rule 26B1 factors. And the factors, we've already, there's 6 factors. You've already got the burden and costs involved. You've already got the importance of the discovery and resolving the issue factor. You've got that covered. You don't have to account for the party's resources or the party's access. That really doesn't involve the assessment of proportionality regarding individual custodians. We could talk about why that doesn't really apply later. But you still got the two big ones, amount and controversy and importance of the stakes. So amount and controversy, there's data out there, there's literature out, there's FJC studies, multivariate. I have some hard data from Time Metric. They're the ones who come up with the invoices for lawyers on discovery. So they shared with me their data. If you put all this data together, you sort of get you can draw the inference that 10% of the amount in controversy is what discovery should cost. Now that's under study now. I have a brainstorming team that's going to be looking at that figure. It's based on a bunch of studies. There is no direct study that tells you that. It's based upon if you take this calculation, you factor this in, and you make this assumption. They're good assumptions, they're reasonable, but obviously these are just layers and layers of assumptions. But it comes out to 10% of amount of controversy. So once you know that, so here you go, you apply this. And at your top level, if you look at John, Joe, Mary, for their emails and file shares, that's $130,000. If you have a amount in controversy case of 1,300,000, that would cover it. If you go all the way to the bottom, if you wanted to get all that discovery from every one of these data sources, from all these individuals, you'd be looking at a $20 million case. Now, I want to look at I want to talk to the brainstorming group and see whether or not that 10% holds true all the way through, or if there's scale problems. So if you're dealing with a $100 million case, are you really going to spend 10 million? Let's see. Yeah, 100 million. Are you going to spend $10 million on discovery? I don't know. I mean, that's why I got to talk to these people, and that's why I got to talk to the brainstorming. I think on these smaller levels, I feel much more comfortable. On a $600,000, if you look at that level, I get all that information, that discovery from emails, file shares, social media, from all those individuals, and that's a $6 million case. And that's what I'm talking to brainstorm, is to see whether or not this is reasonable. So that covers all those factors except for the importance of interest at stake. There's an FJC study that basically says that could tack on up to another 10%. So if you have something that has a constitutional right, that affects a lot of people, that has a societal interest, you can make that argument. You add on another 10% to discovery. So again, the first thing the obvious point to acknowledge is that these projections are based on layers and layers of assumptions, starting with gigabytes and projecting how many documents and pages a gigabyte contains for each data source, which varies significantly. Now we're now entering the hurricane season, and I'm down here in Hilton Head in South Carolina. So when a tropical depression appears in the Atlantic near Africa, the scientists, and you see this on TV all the time, they begin their modeling to project the developing hurricane's possible tracks. Now, when you watch it, you're subjected to daily reports showing possible tracks, right? Looking like colored spaghetti. So that early on, when you're far away from the U.S., the lines go all over the place. There's a lot of outliers, although the bulk of the lines seem to be going in one general direction. As the hurricane nears the U.S., the lines increasingly converge. But even at that very late stage, there are a few outliers where the lines go to different directions. But the convergence of the lines is really pronounced. So I look at that as an analogy for this new framework. You start off, you don't have much information. You need some modeling. You need some kind of a guidance for budgeting purposes, for strategizing, for dealing with the other party. This gives it to you. As you get more information, as you get through the litigation, then you can fill in the assumptions here. We're basing this on 5 gigabytes. In the litigation, you start finding out, now this guy, he's going to take me 15 gigabytes, right? And you've got the average per gigabyte. You plug in that number. Or you say it's only 1 gigabyte, right? For this case, right? You make those adjustments. It also, once you start getting at, you feel comfortable with the data that you have in your own particular case, you can start slicing and dicing as to who you really want, who you're going to produce. You may not want to produce 5 gigabytes because you don't want to spend that money, and you want to get more people with email. So you only disclose or produce 2 gigabytes per the guy to cut down the cost, but get more individual. It depends upon the case. I mean, you may not have in this scenario, we have 5 critical people. The others are really, not there, but you may not know that. And it may not be true. I mean, it may be there's 20 guys. You got a patent case and you're going to have to get 20 of them who have important information. So then you probably would slice and dice as to getting less gigabytes. And if that's the strategy, that's the kind of analysis. This provides you with a format, a framework that you can now defend. You can explain to other people. And here, going back to point 1, and I'll end it here, is right now, the judges have been talking to me and complaining that what happens in a case is that lawyers come up with aggregate numbers. They come into the court, one side says, here's the discovery judge, $5 million. The other side says, baloney, I need 20 more custodians and it's only going to cost you $2 million. Both sides give affidavits showing you pages and pages of these cost figures and coming up there. The judge throws up their hands, splits the baby. It always happens. It happens a lot. What this does, you now go to court. You say, Judge, I'm producing these 10 individuals. We ranked them. We used the GW new framework. We've ranked them. We've made an assessment that these other individuals fall below that. This is based on our judgment that the amount in controversy for this case, a reasonable number, is $2 million. This is what we did. You're going to have to defend that. If the judge says $2 million, this case is worth $20 million. Well, that's up to you. That's why if you consult with the other party and if you both agree, then obviously, you get rid of that problem. But that a lot of times that doesn't happen. So you're just going to have to defend that case. But as you do all these types of decisions, but this gives you that framework, and you go. And instead of arguing, saying that it's one or the other, it's either I get this 5 million extra discovery. You're now going, I want Joe's social media. Judge, it's going to cost me $9,000. I want it. And even on top of this other, I think it's reasonable. Or the other side, it's not reasonable. So that's kind of in a gem. This is built on a lot of work. These numbers they're backed up. Some of it's hard data, backed up on hard data surveys and literature review. Some of it's soft data. Surveys of 2,000 lawyers that the Federal Judicial Center did came up with some of these figures. So acknowledge that, concede that, but it's a lot better than what you guys are doing now, presenting to the court at least. So
Thank you, John. No, this was great. Great explanation. So what happens if I go through that process and my discovery costs projected are going to be 40% of the value of my case for just my key people? Does that mean I can say I'm not going to get everything, you think?
That's where you got to slice and dice and make the adjustments. And so you look at the assumptions that were put in there, first of all. So your assumptions are, 5 gigabytes of email per custodian. So if you want to cut down costs, you take 3 gigabytes. Mm-hmm. And can you make that kind of an argument? Maybe. I think the bigger point you're making is, okay, you have a case and the discovery is going to cost you way more than the amount in controversy. Well, in that case, in that case, what you're going to do is you're going to have to cut down the individual custodian, or make the argument to cut down the individual custodians' gigabytes. Or what you do is you focus in on only those sources that you believe would contain the information. In other words, you wouldn't go to the laptops, you wouldn't go to the social media, you wouldn't go to the mobile devices. You would focus in only on the emails and on the shared files. there's different ways you can do this. You can take it from top to bottom and just, take the, on that chart, you would just take the John, Joe, and Mary all the way across, or you can start going just the emails and just take it from the custodians and just make the assumption, Judge, 90%, 99% of this stuff is going to be on the emails in this case. It ain't going to be on the other stuff. That maybe it probably is on it, but you get more bang for your buck. That's the analysis you guys, this doesn't make it easy. It's a very complicated analysis to begin with because you give you 5 factors and it's, you have all these variables. And so this kind of gives you, what this does is it gives you some comfort level too. I mean, it gives you some kind of ballpark figures so that all right, I'm coming in the ballpark. If I go to the judge, he's not going to laugh me out. If I go to the other side, they can't say right away, I'm super unreasonable. They can argue and maybe they'll convince you, but it gives you some comfort.
Excellent.
And what I was going to add to that is that I think obviously it depends on your industry and what you're getting and what the request is. But much to what John is saying, this gives you a baseline to start from. This has been vetted by various groups, various industries about here's where we can start from. And if you have kind of those targeted custodians that you want to pick on, and I, for example, know that my CEO does not have a lot of email. Like he just doesn't, you're not going to find it. So those are things that you can plug into the framework and then take that to the judge. It's just another tool to use to defend why and how you're doing something.
So in that case, let me show you how that would work out in this framework. So if you had a CEO who doesn't use email, his name on the left hand and on the emails would be all the way in the bottom because there'd be small chance and he wouldn't be that important. He may have important information, but it's very unlikely he has it. So he'd be way down in the bottom. He would be way up on top in the file shares or whatever else, the shared files where the information. So that's where that analysis is needed. But the framework would address that.
Mm-hmm.
Okay. So I'm going to open this up to any of you. How do you think this framework is going to positively impact our industry?
Well, I analogize it much like TAR has eased document review. It brings us into the world more of a social scientist, provides a methodology and a process for moving forward. It provides more structure. Now, having said that, I will tell you that almost all the participants would agree with me on this, and that is that they don't agree with every element of this. And it is built on a consensus, and so from that standpoint, nobody ever agrees with everything. And so we're going to make independent decisions for our clients based on circumstances that we have, unique or otherwise. But it does give us a way to move forward in a documented, regimented, like I said, more akin to how a social scientist would solve a problem.
It builds on what Mandy originally did with her concept. So the concept was identify the custodians who have the most important information at the and it's easy to get the information from them. Once you identify those, well, then you start learning from them, and then you can start talking to the other party, and using this framework, you now have a kind of a uniform vocabulary. And if you can talk like that, and everybody knows where we're going with this, that is what's very helpful. Now, if you don't want to consult with the other party, because we had lawyers who scorched earth kind of policy, and that's fine. That's the adversarial position, and they would keep this information close to the vest, and that's fine. You can keep that confidential. You then would talk to your in-house counsel, and this is what would be very helpful to in-house, because now the in-house knows, all right, I mean, this is what I expect, and this kind of a ballpark figure. I can now talk with the lawyers, and I have a basis now to have an informed discussion.
Do you think that this framework could negatively impact the industry? And if so, how?
So the litigator in me jumps to that one right away, and I will tell you, it's complex. If there's a criticism that we can make of it, it's complex. And as a result, it has the tendency to consume resources and create unnecessary litigation, arguing over individual facts and circumstances, much like you see today in TAR protocols, things like that. It creates satellite litigation. So although I think most people will use this process without ever sharing it with their adversary in litigation, if you get into a situation where show me the beef, so to speak, it could take on a life of its own, and it could be overly complex and cause a lot of other expenses.
Yeah, I agree with Tim. I think that definitely it takes some understanding, and I think that's the other part of the just litigation itself is not everybody can do it. Some people think that they can. They just come up with these numbers because Joe said so, and that's just what he said, or something like that. But I do think that it's good to have in the regard of it can stay evergreen. It can be refreshed. The information, the dollars can be looked at. So from a negative, I don't think it's necessarily negative unless you don't know how to use it. And that's kind of what Tim was alluding to. Not everyone is going to get it. And I think once it gets some comfort level and people understand it and kind of agree to it or just have conversations about it, I could definitely use it internally. Doesn't mean I'm going to show the DOJ unless they ask me. But, you know, it gives me a comfort that I know what we're doing. We're standing by what we're doing. But not everyone can do it. I mean, it definitely takes some understanding.
So that's still our challenge, is to how to articulate this and describe it in a simplified basis. And that's why we're still not there, but this chart that that was just developed, it boils down to this. You figure out how much you're going to spend on discovery. And we say that as a percentage of amount and controversy, but you have a budget, and then you just allocate your budget to the most important people who have that information. And that's all it is. I mean, that's what it's good. Now, how do you get there? And all the numbers, Sonia and Tim are 100% right. You're going to argue about all these things, and they're based on variables and assumptions. So you can argue. The beauty of it is that you can use the standard numbers that we provide you. So it is easy to apply. You just get the averages here, and 5 gigabytes per email, $33,000. Obviously, that's going to be different in other cases. And the biggest problem is this per gigabyte thing. It's a standard metric, but how many pages are in it and how many documents? And determining that affects the single most or the largest factor in the cost, the attorney review. That's what they base it on. It's pages. So you don't have a uniform number, and it varies amongst data sources. So you have a different number of pages and documents in an email versus file shares, and that, which really kind of but these guys went through it. They came up with their best collective information, and you've got it there. You can put in your own numbers based on your own experience.
Excellent. So do you think that the framework will have widespread adoption? And if so, how long? Is this, when do we see this actually have widespread adoption in the industry?
I think people are going to review the framework and take from it what are helpful in their practice. Some people may well adopt all of the elements of the framework, and they may reach out, for example, to Mandy and her team with the software that they have developed, which adopts some of lots of this, and so they may go that route. Others may say, oh, we'll do this on Excel spreadsheets, or we've been doing this on Excel spreadsheets. But what we haven't, because most of us, we did it on Post-its, and then we did it on WordPerfect, then we did it on Excel files, and we've been doing a lot of this. Or first, I guess we did it from the seat of our pants. But I think a lot of people are going to take lots of different things from this that are helpful from their practice, and That's what I think is nice about it, because I think you can take parts of this and to use them in your burden arguments and developing your own proportionality for your own case.
Yeah, I would echo that. I think that it's much like any other evolution. It's going to take some time for people to digest it and understand it and get used to it. And they do that by using it. You know, it's no different than, reviewing or taking off cell phone data or, whatever tool is out there. I think it can be helpful for some, for sure, but it's just going to take a use to get comfortable with what does it do. And personally, I'm looking forward to it, because for me, I think we can use it internally to just have it help navigate the company expenses. That'll help me, go to my GC and say, hey, you know what, this case just came in, but guess what? I already have this. That's just a helpful tool for the strategy of our litigation. And if you're, serial litigant like we are, that is just another piece of information that helps put us in the right direction.
So from experience with the rules, so what we learned when I was on the rules committees, it takes the bench about 5 years after a rule amendment has been promulgated to become comfortable and familiar with that rule. It usually takes the bar 10 years. So before you have general familiarity, just familiarity with the rule. Mm-hmm. So we still got a couple of years before the bar. Although the bar, if you read the case law now, there's an uptick in the cases. Proportionality is being raised more often. So you see that in the case law, and if it's in the case law, that means it's happening more often in the cases. So that answers part of your question. The other part is if 2 or 3 judges in an opinion cite it and say, yeah, these numbers sound pretty realistic to me. Obviously, counsel, you have the opportunity to disagree, and it's your burden now. Tell me why it doesn't apply in this case. If you get that, and depending upon the judge and depending how influential the judge is, things can go really quick at that point.
So I don't mean to interrupt here, but I don't know if anyone is looking at the chat, but we did have a question, and I'll read it to you. And it goes, when estimating the cost using the standard numbers, does this assume that there's a manual review of all the documents collected, or is it based on the assumption as to the use of search terms or TAR to reduce the documents actually reviewed? And then Mandy was actually very helpful and put in a comment, and she says there are standard assumptions around reduction, and there's a second drafting team that will be focused on TAR. So I don't know if any of our speakers have any, if you want to elaborate on any of that.
Yeah, if you look at the Appendix F, and that's what you guys as experts should be looking at. It's a great document. It's an Excel spreadsheet. It's 2 pages long. And so it goes through stages. And actually, it reflects a lot of the budget models that are out there. And there are a bunch of out there. I think this is much more sophisticated, much more detailed, and it's got newer information in it. But they go through the stages. So you start off with the universe of data when you first get it. It could be 100 gigabytes. And then it goes through 4 or 5 stages where it's being narrowed down through by various means. The first one, the deduplication, cuts off a percentage. You have to make an assumption there, how much is whatever the numbers were, and it's based on literature review. Then there's an expansion, because you may have attachments in there. So they built in an expansion in there. And then you start going to the narrowing. Then you start going into the keyword searches, the date searches, the date time frames that typically apply. So that cuts it down. There's 1 or 2 others that escape me. The last one is the analytical, the TAR stuff. And that is still under consideration. That's a problem. To figure it out, come up with an assumption there. There are some general ones, not much in the literature. It's basically based on experience. How much of a reduction does TAR? The ultimate point you get to is the number of pages the lawyer has to review in the first review and then in the second review. We give you an average cost on the first review. I think it's $50 an hour for the attorney. Second review, I think it's $300. We've been trying to get confirmation from others. We've sent out notices, and Tim well knows we haven't been too successful. So if you do get a chance and you look at this, look at the assumptions. We are looking for confirmation of whether or not you agree or you think we're way off, because those assumptions, obviously, they play a huge part. It's $50 an hour, $300 or $200 an hour. And of course, we're dealing with geography, and we know that, some places $1,000 an hour, some places, we know all that stuff. What we're asking for is a general figure, baseline figure.
Excellent. So I only have a couple more questions, and then we're going to go to breakout rooms. But what role do you think the judiciary will play on adoption of the framework, if any?
Well, I sent out a survey actually to a bunch of judges. I didn't get much of a response. I think I got about 20, asking them specifically, would you consider this? Would you consider asking the parties for them to consider it? And would you consider ordering them to follow it? And a couple said they would order it. About half of them said they'd ask the other party to consider it.
Okay.
Half of them said, there's about 5 or 10. It wasn't much of a response, but I got about 10 judges, 5 to 10 saying, well, I don't know enough about this. And 4 or 5 says, no, I wouldn't do it. I wouldn't impose any kind of duty on the parties.
Okay.
And so, as I said, I think the vast majority of practitioners will utilize this without any involvement of their adversary or the judiciary as a methodology to move forward some elements of this. I think that there'll be times when the basic underlying baseline that you start with gets questioned, and you're going to have to then bring that information into the judge, and the judge is ultimately going to be the one to call those balls and strikes again, to say, hey, I cry foul. This is you should be doing more, not less. And so I think ultimately that's the role, and it gives them a better opportunity, because it's more about looking at objective decisions rather than subjective decisions.
Excellent. And same question, but what role do you think corporations or law firms will play in the adoption of this framework?
Well, like I said before, from a corporate standpoint, I think that it is a useful tool. Anything that kind of moves the ball along to targeting and getting the cost, because now most corporations in legal, we have budgets, we have different things. So there is money is a factor, the resources are a factor, whether they're internal or external, all of those things play a part. So it's just another way for me to look at a matter, look at a case, analyze it, and put some real cost to it. Because like you said, the cost of the litigation might be $2 million, but the discovery cost might be double that. So those are, let alone outside counsel fees and everything else. So those things are just a useful tool to make objective decisions about what we're trying to do, how are we doing it, and quite honestly, it gives me a platform to say, here's the proof, here's what we have, and it's not just what I think about my company, because as smart as I think I am, I don't know everything about my company. I don't know everything of what's going on. But if we have a baseline of what is, hear what others are saying, then it kind of validates that and it gives us a step up. So I think that from a corporate standpoint, I know many big corporations and even small ones, especially if you're talking about proportionality, if it's T-Mobile against the dry cleaner, we can both have some common thread of here's what we're going to do, here's how we calculated that, because we're always the big person that they're coming after. And this kind of offsets that. It kind of helps that proportionality standpoint.
Yeah, I agree with Sonia. I think the corporations are going to drive this. They typically are the drivers to efficiency in litigation, And this gives a common theme that they can communicate with their law firms on, and they can actively participate in the decision making.
Okay.
And what I thought was from the plaintiff's side, excuse me, from the plaintiff's side, was always kind of puzzled me, because I thought this information, if provided to the plaintiff, it would be a godsend for a couple of reasons. One, the plaintiff would now have information about the average cost of what they can expect, so that when the defense guy comes in and says this is costing $1 billion, the plaintiff now has some kind of baseline figures. So say, wait a second, explain to me why it's so much more expensive in this case. So it kind of shifts the burden there in that case, and it should also make the plaintiff feel more comfortable, particularly if they're unfamiliar with e-discovery, when they're dealing with vendors, and they could now talk and say how much this stuff is going to cost. Well, now they got a baseline, and it'll be up to the vendor then to explain, no, those figures don't apply in this case because blah, blah, blah applies here, and you got special circumstances. But it gives you some information there that would help them. So it provides it from the plaintiff side, from the defense side. Now you got to feel more comfortable, and you will be targeting individual custodians rather than going to court and saying, or going to the other side saying, defending 20 additional custodians. You go one by one, and then you've got the information in front of you. All right, you want to go to John, you want his social media, that's going to cost me $9 grand. I already provided you $2.5 million. I got you 20 custodians. Why do you, and I don't think this guy's got any information. It's duplicative. And you have that analytical, you have that, the argument right in front of you. It's already, once you have this chart, you can make the arguments just using that.
So one final question, because we've talked about how complex it can be to do all the calculations and understand where the numbers come from and that type of thing. And maybe mostly to Sonia, but do you see a day where outside counsel needs to be competent in how to calculate this if they're going to argue before a judge?
Absolutely. I mean, definitely. And I think from a corporate standpoint, it just, if you use it at the beginning, which I often do when I'm trying to first ingest that case and understand what the requirements are, what am I trying to do, how many people are collecting from, much to what John says, when we kind of go back and once we scoped out different things and they want to add 20, 30, 40 people. And I'm like, wait a minute, like that is ridiculous. Let's figure this out. I do think that there's a chance, and I have to educate my law firms from time to time on, they're making accusations or they're going to the meet and confers and saying, yep, not a problem. I'm like, well, that might be a problem. Unless you kind of consult. I do think it would be a great, I have this e-discovery toolbox. It's another tool in the toolbox. And I think that it can be used if it's done on the onset and kind of throughout the case. Then I think it's kind of a place where you can go back and navigate and say, this is where we started. And then when you kind of set, obviously if cases go on for long times, you can kind of relook at it and say, nope. But definitely counsel should be involved. I think that they could do it. They just have to understand what it is. And much to what we've been saying is what's it's going to be used for me is not going to be the same as our competitors or any other industry or the healthcare. And I think that's the value that it brings. So you can, if you disagree with kind of the base set numbers, you can plug in something else and then still use that as your model.
Excellent. Well,
let me chime in. One thing that I'd like to chime in at. This framing has really evolved, and one of the key factors where it came up with a per gigabyte cost. The judges really wanted it. They really wanted to know some kind of baseline figures. If you look at this chart, I predict that within 2 to 5 years, there will be an algorithm, and there'll be AI doing this. It's got all that data. It's got that information. It's got standard cost. There's no reason you couldn't get an algorithm to spit this stuff out and say, in this case, the amount of controversy is $2 million. You get this this discovery. Then you can play around and you slice and dice and you come up with your special factors and circumstances. And but you got that baseline, the algorithm that cuts out all that complexity.
Good, really good thought. I agree. I'm a huge proponent of AI, so 100% agree. So I first want to thank the three of you for sharing this with us. I think it's been very informative and interesting. At this point in time, I'm going to go ahead and create a couple of breakout rooms so everybody can speak. It would be great before we go in the breakout rooms is if you click the three dots up in the corner of your little box and rename yourself and just put hyphen where you work. That'll help with introductions so everybody knows who everybody is in their room. So again, go to the top right, click on the three dots and select rename and just put your company as well as your name. So I am going to assign automatically and I'm going to keep my fingers crossed that I am able to do all this because I haven't done breakout rooms myself before. We will break out for 20 minutes. We will then come back and report out. So that what that means in each breakout room, you need to pick a scribe or somebody that's going to report back for your group and talk about issues that you have with the process or things that you think are good, conversations about adoption, as well as maybe some of the rates that we talked about. So, all right, here we go. Oh, did I click join? Hi, everyone. Welcome back.
Hi there.
Hi.
I hope you all had some great conversations in the breakout rooms. And I think we just had group one hit the wrong button.
We wondered what happened to you. We thought, oh my God, an alien abducted her. Mike says she was getting ready to give away the keys to the castle.
They don't know how to censor me that well. So I'll make a separate email for that.
I was looking for unassigned people. I saw some and assigned them, but I didn't see you pop up as unassigned.
No, I just hit the wrong button. That's all.
Oh, when you left the room. Okay, gotcha. Okay, well, each room should have a report out. I know I was in room 2, so Mandy is going to report on behalf of room 2. Who's reporting on behalf of room 1?
I didn't do that part. I guess I forgot that part, but I did take notes.
Oh,
So
well, you can report out.
I'll
then.
report back.
And hi, Bill Belt. It has been a long time since I've seen you.
Oh, you're muted.
Hey, everybody. How's it going? Hey, Mandy.
Hi there. Bill deserves
Julie.
chops because he was on the cost committee, and that was a lift.
Yes, it was.
As was Sonia. Yeah, Sonia.
The chart. I highly recommend the chart to people.
That's right. So,
Well, Sonia and Mandy, I'll let you take it from here and talk about what the groups talked about. Any highlights of good, bad, and ugly and fantastic.
sure.
Linda Weber from us took some notes from group 1. If we want to appoint her as our
Why
person.
not?
We'll
It's a group effort.
Right now.
Yeah. Yeah. Let's do it. I'll try to do this, everybody. Hi, everybody. So this is just a kind of a summary of what we discussed. One of the questions that was asked by Andrew in our group was, when you take that 10%, what is that 10% really comprised of? And we were informed, and sorry that we didn't all read it, that Appendix F talks about, it breaks out the costs of what that breakdown is. Is it processing? Is it review? And we think, or we were advised that it seems it's about 75% of that 10% is the review portion. Overall, our whole group repeatedly said that this framework is good for many reasons. And I liked our breakout group because it consisted of various different parties that were some attorneys, some not, vendors, but we all agreed that having some framework that's a general sort of guideline is really, really important for all of us for different reasons, but important. One of the things that we talked about was, and Mike brought this up, Michael McDonald did, and in general, we all agreed that maybe data sampling at the beginning, even though we know this guideline is, this format is this framework is designed so that we can have answers that judges can hear and that two sides can talk about. Still, it might be really helpful to do data sampling as a guide to the metrics for the whole format. And that's kind of counterintuitive because we're trying to say, look, we have a flat line, we have a framework, we have a grid, yet there are so many variables that I think you sometimes have to have data sampling. And I agree with what Mike mentioned on that. Also, I think we touched on this, but getting the word out about this framework, I think, is really important. I didn't mention this before, but just getting the word out so that it is prevalent, because we're vendors, but attorneys need to know about this, judges need to know about this, corporate folks need to know about this. Getting the word out is really important, I just think, in order to, and we talked about that. And then we talked about understanding who you really need as a custodian, and we drilled that down even further than just ranking, and that is, you may think you need, as Sonia said, certain people as custodians, as your main highly ranked people, yet you have to know about that case more to know where that data is, just in case it's down in the engineering department, and that's really your priority. You may not have ranked them as high as you should have. So it has to be a combination of, if that data or all those PSTs are redundant everywhere, what's the core of the case? Because it might be an entirely different person that you didn't prioritize high enough. And we also just said, it seems that from the judicial standpoint, it will help them to understand, because they have so many different, per gig prices coming at them, or so many different ways that pricing occurs, that if we could get it out there, it sure would help from the judicial standpoint, because I know a lot of times many of you end up having to educate the judges anyway, and this would be a consistent format. And then finally, we just talked about, again, we went back to making our estimates, but in a stages format. So if we propose in stages, and could even say, let me know when we hit this dollar amount, it could be a really good guideline, but you're still staying in framework. And that's what we talked about in room 1. Did I get it all, Michael McDonald? Was that it?
The only other thing that the other Michael said was about the liking it because of its mathematical framework, being able to plug up. So I just wanted to make sure that that was a good comment also, that I think a lot of us dealing with numbers just want to get to the bottom line.
That was great feedback. And, one of the things I thought was worth noting was when we did the bench bar conference in March, we had a lot of feedback from the judges during that event. I think we had over 60 in attendance and 12 that were actually speaking on panels. But to your point about the metrics, that was really what it boiled down to for them. It was that at least it gave them the data points on various aspects where they could make a decision based on information. I mean, John touched on the fact that they just come in with, it's too much stuff or it's too expensive. So I thought that was worth noting. I also just wanted to mention that the sampling suggestion is a great one, and that's something that we encourage. I don't know if we specifically called it out in the guidelines. I'd have to take a look, but we did recognize that that definitely should be a practice that would be incorporated to either eliminate burdensome data sources or to potentially evaluate stuff that you want to leave behind in the lower 2 quadrants. So that was a very helpful piece of feedback there. And then also we do address non-custodial data sources from a standpoint of establishing the materiality. So they too get plotted into the quadrants. There's a different set of factors that go into doing that, because obviously with non-custodial data sources, you're either dealing with a stakeholder or a data steward, but you can still go through the same exercise of ranking the relevancy of that content in a source. Did you want me to go through our stuff, Julie?
Sure.
Okay. So Tim basically wanted to know, what can we improve? What can we do better? Corey made a comment that he views this as being something that would be incredibly helpful to deploy at the preservation stage, to make determinations around what is reasonable. And so he was asking about whether or not, we could get traction in that area. I came back with the fact that if you were
John's shaking his head no.
You could try. You could try.
I thought it was a great idea, right?
There's nothing in the rules about preservation.
No. There is in the committee note, the argument's made, if it's proportional, you only need to preserve stuff that's proportional. I think in theory, that's probably right. In real life, you're not going to take that chance. I mean, you're going to have to make the call and persuade everybody that it was proportional, and you destroyed the information. And if your decision is wrong, boy, you're in a lot of hot water.
Well, I came back and said, if you are going to cooperate and negotiate with other parties and you can come to an agreement, of course, you could sample to demonstrate the story and the data itself that maybe you can limit preservation and collection decisions. Hard no from a couple of participants on that as far as negotiating and showing your cards. 26G is the lawyer's responsibility, and they would not want to disclose the strategy. We also had a question that came up around preservation on an ongoing basis. And I had asked about the group's opinion on using this in an iterative fashion, because as we know, as you move through the case, the claims and defenses often shift or move, or some things are resolved via dispositive motions. And so we actually had cases where we did a reevaluation a couple years in, and we were able to not only release custodians, but also lift the preservation obligations. And so we were asking for views on that. And I think generally the feedback was that most people are going to hang on till everything till the end, and that, you know, releasing preservation initiatives during a case is probably something that people wouldn't be interested in doing. Any comments on that? No. And then we talked about cost estimation and the fact that a gigabyte of the volume of data for any data source category can vary drastically. You know, email could be a 5 gigabyte mailbox. It could be a 160 gigabyte mailbox. And so there were some comments about the fact that different types of litigation can generate different data volumes. So, you know, certainly we've built some standards, but those can be adjusted based on what you learn. And some of the sophisticated corporations, they do have good data on, you know, what the averages look like. Some of them have mailbox limits, so they can't go over a certain size. For Amanda, the corporate perspective, she thought it was great. And in particular, the burdensome data sources and grappling with those from a standpoint of just extracting content that's easy to review and actually produce in these structured legacy systems can be difficult. And so being able to carve those out and maybe treat them as a secondary stage was something that appealed to her. Oh, and I forgot one thing. There is, Corey mentioned that there are guidelines on legal hold and trigger, and there is some dialogue on there about, is it ongoing preservation initiatives, Tim? I want to make sure I get it right, because you worked on that drafting team.
Yes, it talks all about preservation and requirements and trigger. Yeah.
Oh, and we also mentioned that we sent the cost survey to, Tim actually sent the cost survey to a number of vendors. We really wanted vendor feedback on the validation around the numbers. I was kind of surprised that Tim said that they didn't get a lot of responses. I would have thought the vendor community would have been interested in participating in that, since they do all things around data. So I was really hoping to see feedback from the vendors just to give us an extra layer of validation around the assumptions. And Tim, any other comments on that? Are we going to try to tackle that a different way?
No, I think we're still working on it, but it's definitely something, John, we need to talk about and try to see if we can come up with a better idea. Like I said, maybe it's about issuing the survey more in small, meaningful chunks rather than this long survey that people were overwhelmed with.
We would love to help on, you know, from a vendor side, with anything that you guys may need, like questions asked, or, you know, usually what per gigabyte prices are.
Maybe we just do, maybe there's ways to categorize the inputs and assumptions so that, you know, because they know a lot of these numbers right off the top of their head. I mean, they do this all the time.
Would it be interesting?
The survey was only on the assumptions.
Oh, it was? Was it on everything as far as input costs and reduction assumptions, everything?
Yes.
There's 8 questions, 8 or 9 questions.
8 or 9 questions? Well, that's not a lot.
No.
But they had multiple, they sort of had multiple parts in the way you looked at them.
Yeah. All right.
And from the vendor's perspective,
on my end, I don't see, it used to be like 25 a gig in, 150 out. Now the vendors look at the whole project. So I'm not surprised that vendors didn't reply, because it's not like everything's negotiable, but they've become really flexible, especially in the last 5 years, on how they're going to be pricing stuff. And if I were a vendor and putting something in stone, it's sort of like what we were talking about in our group. How much is it going to cost? I can't say, you know, and for a vendor who's selling their services, that's difficult to say. For a schlub like me in a office across from the bathroom, it's pretty easy. But I would think that vendors, you might want to take a more flexible approach with them and not have a single line item. Just say, how do you approach pricing? And go from there.
You can't, because
it's, if you came to me with 10 gigs and I said $25 a gig, it's $250 a month, no one cares. But if you come to me with a terabyte at 25 gigs or $25 a gig is $25,000. So there has to be an economy of scale, and it's gotten cheaper too. I mean, we can go out and buy cloud storage and, you know, add terabytes, you know, with a call to the data center. It's kind of cool, but other things that it's interesting when I look at the numbers on the framework is that, you know, we started looking at all the cases we have. What's the data size? What's the custodian count? What's the file? What's the number of file types in there? You know, if you got an engineering firm's going to have AutoCAD in there. So all of a sudden the gigabyte price, you know, it's, you know, 250 megabytes to review, you know, that's one file versus an email that could be 1,000 emails. So it's, you know, but I suppose we could go down that path over and over with every new software that pops up.
I mean, the only thing I can say is, I remember when I said it was complex, it's complex enough. And now if we started adding things like, there'd be variations depending upon the size of the project, it would even be more complex. So what we tried to do is allow people the opportunity to make meaningful decisions about discrete object chunks for assumptions. You know, look, if I came to you and I had, like you said, 25 gigabytes of data to process, what would your price be? Everybody knows that there, you know, it costs less per the more you have, but you know, that's another factor that would have complicated things, and we were already complicated.
Right.
So along those same lines, let me tell you a challenge I've had from day one, and it's dealing with experts like you, and that is it seems like the focus is on the 20% of the cost, and you really want to dive down in the processing and in the collection cost, because there are so many different variables and there are complexity. But at the end of the game, it's only 25% of the cost. Yeah. What I'm looking for is the attorney review and how many pages are produced. And that's where I need the you know, that's where the assumptions, you know, how many pages out of a gigabyte are going to be produced for the attorney to review. That's where the cost is coming from. And that's where, you know, I get it. You can fine tune and refine the processing and the collection cost, but at the end of the game, it's the attorney review time. That's critical.
Well, I must say I was listening to my group more than I participated, but I'm really excited about the framework. I think kudos to you guys. You know, I've been one of those people who have started with a blank spreadsheet many times and created this, you know, the client has 150 gigabytes. Well, here's what's going to cost all the way through review or production, and to get them to go back and get less data. But it was a, you know, computational process that I developed kind of from the ground up, and then I'd find a case and it wouldn't work anymore, so I'd have to try something else. So I like the way you're prioritizing custodians. I like the way you're prioritizing data that's easy to get versus hard to get. That was never part of my calculation. It was more just a per gig kind of estimate. So I'm excited to try it. I really am. And the next large case, I will give it my all. I also think I agree with the group that said we have to get the word out on it. I've been with a lot of different groups over the years, and it took, like, the LEADS group that came out with the e-discovery billing codes took, I don't know, 10 years to get for anybody to recognize it. It was a really long time. But so, you know, maybe find some champions that are willing to use it and then blog about it, write some articles on it to get some attention. See if you can get on, I don't know if you've done Tom and Rocky's show yet. Tom O'Connor and Rocky Messing, they do an interview. If you can get on that usually hits a lot of people. Or Ari Kaplan, get him to do an interview with members of the committee, because that'll start getting the word out that it's out there, right? And then when people start looking at it, that's when you're going to start getting people to learn about
So
it.
let me ask you your insights and your advice on timing. So we have two components here. We have the Appendix F, which is that sophisticated Excel spreadsheet cost data. That's really good. That's available now to be used, except it doesn't have a key component, and that's the TAR aspect. And depending upon your business, TAR may be in the whole thing, maybe the whole game. So we're working on that. The question is, do we publicize that now, the Appendix X, make it widely available, and leave that hanging and saying that stay tuned on that? So that's one issue. The second issue is the framework itself. Like I said, it's being expanded, so it covers the entire Rule 26B1, which ain't going to take much. It's going to take 2 additional paragraphs on addressing amount and controversy and importance and stakes, and just plugging that in and refining this rudimentary chart that I came up with. That shouldn't take much time. When that's done, the whole framework, the 25-pager, is going to be published for public comment for 8 weeks. Be sent to all judges, a lot of mailing lists of 4,000 or 5,000, and then I hold a conference in the spring to go over the comments. So that's what we're doing on as to the promoting it and sampling it. The Appendix F thing and the TAR thing. What do you think about that? Should we wait? And because I don't know how useful, and I don't want people using this and saying, well, this isn't useful to me. This is a bunch of nothing, because I'm using TAR. And TAR is, is the big deal, and it's got most of my costs. So I don't want people to be turned off by it. And you got any insights on that?
I mean, my thoughts, I can't wait to sit down with it and try it, because I want to see how much I want to tweak it for my case, because if I know numbers and things, how flexible it is. To me, I would treat TAR for my purpose as nothing more than a reduction in the number of documents that have to be reviewed. But that's because I don't pay for TAR. Like my software, it's included, it's free. So I don't pay any additional cost to use TAR. It only reduces the number of documents. So to the extent I could add an extra discount, I would just do that of the number of documents. It's more complicated, I think, calculating what the results of TAR are going to yield in a given case, depending on the type of documents. And I mean, we've had cases where we've reviewed as few as, I think 4,000 and out of hundreds and hundreds of thousands and hit our numbers. And then we've had somewhere where we reviewed 25,000 to get there before we can get where we need to be. So before like if we're talking about it at the point of identification and collection, that makes it hard if I can't get samples and do all that up front to figure out what that looks like down the road. But I think that's going to be true anytime. I mean, to me, the beauty of this is the client says, here's how much data I have, and I go off and say, here's how much it's going to cost. Are you sure? And whether I'm using TAR or not, that initial number is helpful to talk about. Let's talk about the value of the case. Let's talk about if this is where we need to be, or do we really need to talk about a better strategy for collection? What are your search capabilities? What are your, culling capabilities at your end? Which we typically end up doing anyway. But
can I make a couple comments on that, John?
Yeah.
Sure.
So this is Bill. So I've been using the calculator a lot. In fact, as we were developing it, I was starting to use it, and have basically used it all along. Still use it. Number one, on TAR, we do have just kind of a placeholder, simple input you can put for kind of like what you're talking about. Here's how I think TAR is going to impact the review on this case. So you can include that in there, and right now it's really rough. It doesn't incorporate a lot of the processes that are more and more baked into TAR process, especially like relativities, review process. I now see it in Disco. And that's, I think, coming together as the TAR 2.0 process. I think it's coming together is something that people generally recognize. So that's coming, but there is something there for the meantime. And then secondarily, as you're using it, the thing that I found most helpful is to have like you're saying, start with the data sizes, and then plug in your numbers, and then see what you come up with. And a lot of times the number that it spits out for you is a little bit like, oh yeah, hold on a second.
Right.
And then you can go into the chart and see, you can input some tweaks, and you can see the tweaks that really, move the needle. And to me, that's like, I think it's kind of what you're saying. It helps that conversation.
Right.
I'd like to add something on the calculator, because after the bench bar conference, we were fielding calls from some of the corporations who attended that event. They said that one of their struggles is that, some corporations are very, very sophisticated and efficient as far as e-discovery processes, and some are not. They don't want to use actual numbers from a standpoint of putting together a budget. And their belief was that up until now, there really hasn't been any kind of reference guide that they can look to as a starting point for doing cost estimation. So we heard from quite a few corporations that they're going to start to use this calculator as the baseline for putting together budgets. And so I think that it's a resource that's been needed for a long time. We've all been doing it our own way, but I think to hold back on that, even understanding that it's going to be, and that was the other thing the team grappled with a lot. What we're doing right now and what we might be doing a year from now could be drastically different. So this calculator is going to be a lifelong, whatever, it's going to be perpetually probably modified and updated, hopefully, as the technologies and the processes improve. So I really think there's a lot of value to having it out in the public sector, and it's already being used, for the people that have heard about it.
Well, excellent. Well, I want to be sensitive to everybody's time. So we are going to call the session to an end, except we're all going to stay here. Whoever wants to stay here is free to go get a beverage, and we'll just have a little chat about whatever topic you like.